Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey. Today we're discussing structuring subject to and seller carryback transactions. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to the channel. Also, we value your feedback. Leave us a comment. We would appreciate it. With that, Sean, give us a legal update.
So today, my legal update is about anonymity using LLCs. So I have a lot of clients that come to me and say, hey, Sean, how do I create anonymity with the use of LLCs? And, so I'm able to advise them or discuss how to do it. But one thing I do want to make clear is anonymity is not what, is true asset protection. When we talk about asset protection or business planning or asset planning, anonymity is not that. In fact, asset protection is basically obtained two ways, primarily through insurance. There is no substitute. There's nothing that we can do as attorneys that would substitute a strong insurance policy with high policy limits, an umbrella policy. Those types of things are going to provide the best protection. The secondary protection is creating a corporate veil. So basically creating the corporate veil between personal assets and business assets. And then even on the business side, creating a corporate veil between different businesses. So, if you own multiple businesses, you want to structure those to create the corporate veil. So now I've used the word corporate veil. What does that mean, right? I'm using legalese here. Well, a corporate veil means basically that you're forming LLCs, which are limited liability companies or even corporations, and you are conducting business through those entities versus commingling your personal assets with your business operations. So if you're going to do business, you shouldn't be doing it in your personal name. You should be doing it through a limited liability company. And then if you have multiple businesses, let's say that you operate, rental properties, or you own rental properties, you might want to consider having different LLCs for your rental properties, for each rental property. If at the same time you're also doing, let's say, wholesaling, so you have a separate wholesale business, have that separate wholesale business in a different LLC than the LLC you use to own your rental properties. So if you have different businesses, you create a separation between the businesses as well. So each business is, owned by a different LLC. That's what we talk about when we talk about asset planning. Anonymity is different. Anonymity is just what it says, which is anonymous, which means that somebody who's searching the public records is not able to find out or determine who owns a limited liability company, for example. And so that is anonymity. And some people consider it a deterrent from lawsuits. Other people want it for various reasons, so that maybe certain contact information is hidden, certain addresses are hidden, as far as, maybe the principals are well known or are famous. And so they want anonymity because they don't want, their address information or contact information out there in the public realm. And so to do that, though, there's using an LLC. There's other ways, such as, land trusts and things like that. I'm not going to go into that. But to create anonymity using LLCs, The main process is to form a Delaware LLC or a Wyoming LLC, or to form an LLC in some other state that does not require the names and information of the members and managers to be part of the public record. So for example, in Delaware LLC, you file basically one sheet of paper, and that sheet of paper has the name of the entity. It does not say who owns the entity, who the members of the entity are, who the managers are. It's simply, we're forming this entity. Here's the name. And then the promoter, that can be an attorney. It could be a statutory agent. It could be somebody else, that's signing it. They sign that paperwork and they file it with the state. And then when somebody searches those state records, all they see is that one sheet of paper, which has the name, and it also will have like the stat agent. You have to have a local stat agent, which is just a corporation. Like, there's a number of them out there that will act as stat agents for limited liability companies or corporations. But that's all that's on that one-page sheet. Then you can take that limited liability company, and then you can make it the owner or the member of other LLCs in states like Arizona that don't provide that certain level of anonymity. So in Arizona, the ownership or the membership in LLCs is public record. But if it's a Delaware LLC that's the member, you file with Arizona and you say, okay, I'm forming this LLC in Arizona. The member is this Delaware LLC, and that's all that's on record with Arizona. So once again, the only way, if somebody were searching Arizona's Corporation Commission and they see, oh, there's an Arizona LLC and it's owned by this Delaware LLC. Well, who owns this Delaware LLC? Well, then you go to Delaware, and all you're receiving and all you can receive is that one sheet of paper that doesn't tell you anything. Now, the question is, well, how do you know who the members are? How do you know who owns the Delaware LLC, for example? Well, you have to have, if you're going to form an LLC in a state that you're not providing membership information, you have to then have an operating agreement. And that's the requirement of Delaware law, for example, is that you have to have an operating agreement which document would then define who the members are and who the managers are and how the company operates. So that's the process of obtaining anonymity using limited liability companies. But once again, and I do want to emphasize, anonymity is just that. It provides, or hides certain information from the public realm, but it's not, true asset planning, true asset protection. That comes through insurance and creating that corporate veil.
One common mistake I've seen with clients when trying to deal with anonymity or trying to deal with LLCs formed in separate jurisdictions, because that's inevitably what you're going to be doing when you're trying to get an anonymous company, right? If we've got a client here in Arizona, they're going to need to go to Delaware or somewhere else. A common mistake I've seen is they form ABC LLC in Arizona, and then they go form ABC LLC in Delaware, and then they go form ABC LLC in Wyoming. And to them, they think that's just ABC LLC. The problem is that's ABC LLC, an Arizona limited liability company, or a Wyoming limited liability company. They are separate companies in the eyes of the law. So the formation really doesn't it start with the jurisdiction that allows anonymity, but then coming into your local jurisdictions or wherever else you want to be and have it recognized or registered to do business or domesticated in that state.
Yeah, that's exactly right. So the starting point is not a state that does not have anonymity. The starting point would be the state that has anonymity. And then it's important to note that Delaware or Wyoming LLC should not then be the operating entity or the entity that owns real estate. Because, for example, if you have a Delaware LLC and you start using it to purchase real estate, say here in Arizona, and all of a sudden you have a lawsuit on your hands, or you need to pursue a lawsuit because, say, you've entered into a purchase contract using that Delaware LLC, the seller is refusing to perform. So you decide, oh, well, I want to pursue a specific performance action. I want to force them to sell to me. Well, in order to do that in Arizona, you have to domesticate the Delaware LLC, because foreign LLCs cannot pursue claims in court in Arizona without first domesticating. Well, what's Arizona going to require when you domesticate? They're going to require the membership information of the Delaware LLC. So you're going to have to put down in the public domain and in Arizona, well, I'm domesticating this Delaware LLC, and this Delaware LLC is owned by so-and-so and so-and-so, when you weren't otherwise providing that information in the public realm. So you have to understand that the Delaware Wyoming LLC should be the holding company of the LLCs for which you're going to operate or which you're going to hold property in states that don't provide the anonymity.
Sure. All right. So today our topic is structuring subject to and seller carryback transactions, a big topic, an important topic in the area of real estate investing. Today on the show with us, we have Scott Horne, attorney and owner at Hornet Associates PC in Garland, Texas. We're happy to have him come and talk to us about his experience and history in preparing and working through the subject to and seller carryback transactions. Scott, thanks so much for being with us.
Thanks, guys.
Tell us about Hornet Associates and what services do you offer through your firm?
Well, we're a little bit more of a boutique firm, but we do offer everything revolving around the real estate investor transactions, Andy, in that we work with investors from the acquisition and sales side. We are title attorneys. We have our title company as well, so we can help them close either the front or back end type transaction along the way. We are heavily invested in all aspects of the creative finance world, which includes everything from lease options to lease purchase or rent to owns, what do you want to call those, all types of owner financing, whether it's straight seller financing, the subject to or wraparound type vehicles that can be used. We do landlord tenant representations, and unfortunately we represent our investors around Texas doing foreclosures for them if and when that comes up, or helping them through appropriate workouts along the way. Now from there we can work with our investors as needed from a litigation perspective, but we don't do that ourselves. I have outside litigation counsel that we have worked with for many, many, many years and more or less trained and brought up in this industry so they understand it.
Now, I understand this is an interesting story and one I think our listeners would be really interested in, but how did you, Scott Horne, get involved in creative finance?
Well, I told you earlier that could be like a 2-day conversation, but
Give it
try to
to
keep that in 2 minutes or so. I had a job for 1 year out of law school back in, I got out of law school late 1993 or early 1994. And went to work for a real estate development firm here in Dallas as in-house counsel. And of course, as both of you know, when you are a young lawyer, you don't know anything. We don't know up from down. We're learning, right? So you start to learn the real estate industry through that legal process a little bit. But in 1985, of course, that's when the real estate crash hit back then. You'd have to be a little bit older to go back to those days. And I mean, you are on the street. And at that time, a huge recession going on. And I didn't realize you couldn't get a job in the middle of a recession because no one's hiring. So all I knew to do was, because I've only been trained for a year as a real estate attorney, was to go out and try to find real estate deals. And I put together a syndication, which is nothing more than a fancy word for marrying property with the lender, with the buyers, on a 100-unit duplex transaction that was in foreclosure. Unfortunately, just before closing, they created the RTC and they changed the tax laws, and it collapsed everything and just caused havoc in the real estate world out there. And of course, everything fell apart at that point in time. You lose hundreds of thousands of dollars in commissions. But somehow I stepped up and I called the banks that were foreclosing and just asked, hey guys, what's next? Do you need help? And they did. And we became a property manager, and they hired me to do this for them. I guess I was lucky to be able to talk a good game, having never managed a piece of property in my entire life. But they were all out-of-state lenders. They needed help. And so you go to the law library, because we didn't have the internet back then, guys, to read up and learn about property management. And we actually had to type our own leases back in that day and your own documents. And when you do that, it logs things in your brain, as I'm sure both you and Sean know, Andy. And you start becoming a property manager, and you learn how to talk the game. And one thing leads to the next. I was in the commercial world for many years, trying to sell apartment complexes, high-rise office buildings. Again, when you're young and, as I say, stupid back in those days, you don't realize you can't buy and sell real estate in a recession. It just doesn't happen. Learned a lot, though, in making hundreds of offers on properties through governmental entities, major REITs back in those days and things of that nature. But you learn a different aspect of our business. Got involved, and I was hired by a gentleman who actually created all of the frequent user programs. He was the innovator for the air mileage, bonus mileage, as well as the hotel guest items that they do today. And they hired me to come in and buy apartments from them. And I had huge money behind me, and went out and bought my first apartment complex, got screwed by the seller, didn't know what I didn't know. And of course, my job was to rehab the property, staff it, do everything with it. Never done it for my entire life. So you learn to go and do, and you make things happen. And that real life practical knowledge gives you a lot of experience. And along the way, you try other things. Unfortunately, the owner of the company went through his 5th or 6th divorce, moved to Honduras. You're back on the street again. And eventually you go, I've had enough. And so I started my law practice, doing whatever walked in the door, learning the game, as we all do at that point. And actually did my first house with another attorney from a church I knew. He brought the money in, found the house. I had met a contractor, and we did the rehab of this home. Did it, got ready to go to the market. And on December the 24th, I get a page, if you guys remember pagers, because we had the bag phones back in those days. And there's water coming out of our front door. And it's like, oh my gosh. So yes, unlike in Arizona, here in Texas, things get cold sometimes, and the water lines had broken upstairs, collapsed the whole ceiling downstairs. Thank goodness for insurance.
Well, what I love about a lot of that is, you know, you're essentially in both your real estate investing and your practice of law, your talents were forged in fire, so to speak. I mean, there's so many lawyers that are so dependent on forms, and when you've been forced to work through a form word for word, there's no more boilerplate at that point. I mean, everything is you need to understand at a baseline level, and it's just going to make you better in all aspects.
Not only that, Andy, but you have to learn how to go research it through all various functions at that time. Most people rely upon either information from other investors today out there. And of course, we all know whatever the investor tells you is true, just like whatever you read on the internet is true, right? And they use that as a crutch. And you are so right that when you get out there and you have to do it yourself, read it yourself, manipulate it to fit the transaction, it not only do you learn it better, but it logs it in your brain better so you remember it. But with this instance, through this, I'm in my office one day, and this young man who had just been out of school for a few months, he was actually living in his mother's beauty shop, back room, puts his head in the door and asks me if I know about sweat equity under FHA guidelines and whatnot. And I'll just tell you, one thing led to the next, and we started buying houses. What you don't know is that when you have that great diploma on your wall, when you have your relative good looks, which I'm a little bit short on, and you got a quarter, all that gets you is a cup of coffee, right?
Right.
And I don't know how to go out and get financing. And we're borrowing what today is known as hard money and at very expensive rates. And what we learned later is that this particular lender he worked with, his goal was really to lend money in order to foreclose and take the properties back. It was the way he acquired properties. Fortunately, that never happened with us. We got it done. But what we learned in doing that game is that so many other people made money in the transaction, we didn't make it. We spent too much money in the repair side. Realtors got paid, title companies got paid, mortgage companies got paid, and we didn't. And we start learning creative finance. What was so interesting about my career, I'm sure you guys have the HomeVestor operations in Arizona, and you know what those are. So Ken D'Angelo, who started HomeVestors, back in the late 80s, early 90s, we were flipping houses back and forth to each other. We would get together all the time and talk about creative strategies, be it options or whatever it might be. And everybody's trying to figure out how to make things work. And we're all learning the game together, which is where he came up with the concept of really more or less advertising in bulk was what HomeVestors was originally set up as. And then it morphed from there. So with that, we learned a lot of things, and we learned to start buying houses in volume. You have to go meet your banks. You have to learn how to put together a financial statement, what you need. You have to learn how to talk to bankers, because eventually, if you're going to be successful in our business, you cannot continue borrowing hard money. You've got to get cheaper sources of money in some format. And again, I could go on and on about this, but we eventually got one bank to do one deal, and one deal has turned into over 7,500 houses. You realize, I didn't realize at the time that we were kind of a wholesale operation, even though we didn't flip contracts, but we had 10 people in our back office disseminating offers every day of the week. And we started buying 20 houses plus a month. And when you buy 20 houses a month, what you learn is you cannot buy 20 houses month one, month two, month three, because then you got 60 houses and the interest carry kills you. And you have to learn creative techniques in order to get those houses income producing. And at that time, we got creative using the lease purchase documents, the contract for deeds that we could do back in those days. And we did things differently. And then we learned the mortgage game, where we could buy a property, renovate it, get it income producing very quickly using a contract for deed. We would hold a mortgage in escrow, pre-executed, so that once our borrower did X, we would record the mortgage, and then we would sell that mortgage in bulk. And that game evolved into the creative finance side a little bit. And we became one of the largest single family owner finance generators and sellers of that paper into the secondary market through the 1990s. Well, along the way, some people might remember the old FHA non-qualifying loans. Those were great. Of course, they did away with those in 86 and 88, so they kind of filtered out relative. But when you ever could find those, it was a great opportunity to buy a home and simply take over that loan. And that was really the precursor to what we do today with the subject to type transactions. But through the 1990s, it was so easy to buy houses and to buy them inexpensively. You didn't see or hear a lot about the creative finance game. It wasn't really until 2008, 2009, when the crash hit, that the whole world was crashing in around the investors. And here in Texas, and especially in the Dallas-Fort Worth marketplace, just because of our exposure, both as a real estate investor, at that time, we were one of the largest hard money lenders in Texas. Everybody was coming to me as that lawyer to go, what do we do? And the answer truly wound up being wraparound mortgages, creative finance, and things of that nature, because you could not sell your house to a home buyer because they couldn't get a loan. And you had to find other mechanisms. But the problem is that at that time, there was no structure for it. Everybody had gone brain dead in the subprime era. No, if you could fog a mirror, you could sell your house to somebody. And then this creative finance game just exploded out of that. And so through this time, I started creating disclosure documents that we use to go along with the contracts here to lay out all the things that we had learned over the last 15, 20 years in the industry that you needed to do in a seller finance transaction, whether you're buying it or selling it. And from there, never anticipated that what we have done would lead us to become one of the largest attorneys in Texas to do the creative finance game there, but awful glad that we have. And today, that's where we are. And our law firm works with investors across Texas in that regard. In fact, we work with investors across the country now as a escrow and closing agent for them in helping them structure and provide the right documents for their closing, regardless of what state they're in. We still buy houses using all types of mechanisms, whether it's direct owner finance, subject to wraparounds, or bank financing, whatever it might be.
Well, I think it's important for listeners, especially listeners that are real estate investors, to see attorneys that went to the creative finance university, so to speak, on their own before they started practicing law and came to the table with real world experience, knew what it was like to get it done, and knew what it was going to need to be like to get things done in a bad market, right? That's when ingenuity is required, and in the normal state of things, we get fat and lazy, and it becomes, well, if there's not a form out there, I guess we can't do it. And your whole story, I think, shows, forget the forms, we'll figure out a way to do it, and figure out how to move and make money regardless of the market. So we want to talk about some specific areas of creative financing, transactions that you guys handle, what you're seeing currently in each particular area. And we want to talk with you. What are you seeing? Well, you've mentioned it a couple times, so I'm assume you still do it, but agreements for sale or contracts for deed.
So different strokes for different folks in different marketplaces, right? So, contracts for sales, are easy. And I always suggest and recommend using a state promulgated form whenever that is possible. I know that there are a lot of gurus and trainers out there that try to create their own document that they can use in all 50 states, and that's really hard to do sometimes. And I prefer to use state promulgated forms and to supplant that with proper disclosures to spell out what it is you're trying to accomplish. And I often tell investors, don't just go to the internet and pull some form off. And if you get it, read it. Understand what it is you're trying to accomplish out there when you are putting a house under contract, whether it's to buy or to sell. And so often they don't do it. And I can give you an example with some guy. And as I'm reading through the contract, it's a Georgia contract with the state of Georgia. All of that is just like timeout. Anyway, I want investors to always try to understand what it is they're doing and become a student of this game, understand what needs to be in the contracts. When they're looking at someone else's deal, they get it. The other thing I think real quick, Andy, is I see a lot of these one-page contracts. I'm sure you guys might see the same thing in Arizona too. Using such a simplified contract. And it's because, the seller doesn't understand anything else. It confuses them using a state promulgated form. And of course, my response to that is, how do you think they bought the house in the first place? Using the same form. Anyway, people try to find shortcuts to everything. And of course, sometimes that creates problems, and that's where we lawyers step in and have to take care of things out there. Now, you brought up contract for deeds. And contract for deeds are great in most states. Here in Texas, not so much. We can buy a house as an investor with a contract for deed. Absolutely not an issue or a problem. That's just contract law. The problem comes trying to sell it to an owner occupant or a consumer in that instance. Our Texas property code takes over and pretty much negates it. And today, I'll just say we lawyers steer away from contract for deeds 100% when dealing with a back-end consumer type transaction.
Scott, Sean St. Clair here. Thanks again for for joining us. So it's interesting that you mentioned contracts for deed and the state statutes. So in Arizona, we don't have that. We can do contracts for deed.
I'm jealous.
In Arizona. However, with that said, state law doesn't have a prohibition, but of course we have the DoddFrank requirements. Talk to us a little bit about DoddFrank, and the limitations that that poses for creative financing.
Sure. Sean, whenever you're dealing with a consumer under any type of a document, a contract for deed, a contract for sale, maybe even a lease or a lease option, possibly, I think you need to bring into effect DoddFrank and the SAFE Act that kind of go hand in hand with each other, as well as RESPA. And, Texas has had a de minimis rule for the SAFE Act. It used to be 5, today it's 3. What most investors don't ever realize is that RESPA has a 3 property de minimis rule, meaning even though you might be 5 with the SAFE Act, you're still really 3 because of RESPA. And DoddFrank has what we believe is a 5 property de minimis rule. So if you do 5 or fewer transactions in a 12-month period, technically you're not under DoddFrank. Now, even though a lot of investors think, well, I'm not under DoddFrank, therefore I don't need to comply, we recommend and suggest every single deal comply with it. Better to be safe than be sorry. When you look at DoddFrank, well, let me back up. Let's look at the SAFE Act first a little bit and how it affects us. And if you're going to put a consumer in a home that is supposed to be their homestead or their residence in some format, I think every investor out there should comply with that, regardless of what type of a transaction it is. The SAFE Act, of course, says that they're supposed to incorporate into the transaction a knowledgeable real estate attorney, and that you should provide the borrower the same disclosures they'd get under RESPA. And of course, the way you do that is you process that buyer using the residential mortgage loan originator. So we do that here in Texas in what we call the owner finance network. We have our loan originators. We're licensed in Texas, and we do underwriting in all 50 states out there to help the investors, ensure the ability to repay for the homeowner, which is the main thing. We call it the ATR rule. You flop over to DoddFrank, and of course, DoddFrank, you want investors to learn the buzzwords, which is we are to consider and verify, and those are the buzzwords, a borrower's financial ability and the information they provide to ensure that they have the ability to repay the loan. And what we're looking for is we don't care about credit. Credit really doesn't drive it. What we care about is, do they have a job? Do they have income? And can they demonstrate that sufficiently where they can afford the house under a reasonable debt to income ratio? I'm sure both of y'all know that the big banks, the B of A's, the Wells Fargo's, et cetera, they're under a 43% debt to income ratio max today. Now that might change somewhere along the way, I don't know, but that's where DoddFrank holds them to. For the investor, we're more or less under a reasonableness standard, and that changes based on, of course, the price of the home and the monthly payment. For instance, if your borrower only makes $3,000 a month and their mortgage payment is going to be $1,500 a month, that's 50% debt to income before you take anything else into consideration. But if your borrower makes $10,000 a month of income and has a $5,000 payment, you've got a lot more disposable income there to look at. So there's this balancing act that I always recommend that the investor kind of learn, and never push a deal. I see so many investors, they just want to get a deal done, get that big down payment in their pocket, et cetera. And it's like, stop, guys. It's not worth pushing the deal and setting up the bar to fail if the numbers aren't working. Pull back, wait. There are plenty of buyers out there to go with. Now, from there, once you consider and verify it, I think the investors need to learn the 3 criteria, 3 levels of DoddFrank. There's QM, or the qualified mortgage. That's mostly where our big banks live. There is high cost, which is the middle section, which is where we investors want to live. And then there is high price. If you get into the high price category, which is going to be anything that exceeds 8.5% over the APOR, and we'll talk about that in a minute. APOR is the average prime offer rate, which is a every week published rate by the government that comes out every Tuesday. But once you exceed 8.5% over the APOR, if you're doing a wraparound mortgage, you're into that high price category, and that's a problem. You have to send your borrower to take an online class through HUD. And although I've never taken that class, I've never seen it, what I really believe they tell you is you are stupid for doing this deal for such a high interest rate. And I don't want to go in that level. There are some investors who do, so long as you comply with that and make sure you have all the proper RMLO disclosures along the way, it's okay. I think you're pushing the envelope a little bit too high, though, at that point. So we want to live in the high cost range, which is anything under the 8.5% and under the APOR. Now, what Dodd-Frank says is that interest rate calculation. APOR, let's say that's 4% today, plus 8.5 means that the APR, or the annual percentage rate, cannot exceed 12.5%, for instance. And it's understanding and having the investor ensure that when they run their calculations, their interest rates, any points, any other mortgage fees that might be related to a mortgage type origination, that they run that to make sure that their APR is below that threshold. And of course, I'm always suggesting don't go up to that threshold. Try to stay reasonably below it just to be safe out there a little bit. I don't ever want to be in a courtroom and be accused of either predatory lending or be accused of taking a buyer's down payment knowing they can't afford the payment out there. And I have no doubt, guys, that in Arizona, like here in Texas, we still have bad actors who do things like that all the time. So I think the investor needs to have a good understanding of the SAFE Act. They don't need to be an expert at it. They need to have a reasonable understanding of Dodd-Frank, what you need to be looking at and doing in that instance. We recommend to process buyers every time. And I like to do that also, guys, just because when you can create a seller finance transaction to be as traditional and customary as a normal mortgage might be, I think it makes the buyer feel more comfortable. You're going through the same processes. And the key here is to make sure our buyer is not only protected, but everybody is comfortable in the transaction as well. So that's a very important issue, I think, for the investor community to understand. Take the time to learn it, understand the basics at least, and then move from there.
So when we talk about Dodd-Frank and the SAFE Act, really, correct me if I'm wrong, but those are more of a concern on the disposition side of real estate, right? So if you're an investor and you're acquiring the property and you're wanting to acquire it by creative financing, you don't really have to be concerned about Dodd-Frank, the SAFE Act, that type of thing. But it's on the disposition side when you're basically handing off the property to a homeowner, somebody who plans to live in the property and plans to acquire it, whether via contract for deed, via seller carryback financing, so that the investor is providing the seller carryback. Is that correct?
Yeah. When we are acquiring a property as an investor, we call that a commercial transaction, non-owner occupied. It's the Wild West. So long as you make sure contract law is going to govern, and it's really what the important part there is making sure that your seller understands the transaction and making certain that you have disclosed properly to the seller what the issues and the risks are in these types of transactions. Now, here in Texas, we have a few rules and regulations you don't have in Arizona. Even as an investor, if we're buying a home subject to the existing debt or through a wraparound format, we have what is called the Texas Underlying Lien Disclosure Notice, which is the seller is required, it's a mandatory requirement to provide a promulgated disclosure form to the buyer in that regard. In addition, we have a new insurance disclosure form too. Now, here in Texas, and I'll bring this up, we have a new law that went into effect in January. It came out of what's called Senate Bill 43. And it happened because of one investor in El Paso, Texas, who took advantage of all the Hispanics who came across the border, wanted to buy a house, took the big down payments, didn't process a single one of them, foreclosed on them all, and resold the houses again. I'm sure he got sued there for what he should have done. But that one guy changed our laws in Texas. And of course, we're always trying to tell investors, we need to self-regulate ourselves, get these kind of guys out of the business, and try to do things the right way. So Texas has a few things that we got to think about, even as an investor with Maintain. And one of the new requirements is no more kitchen tabletop closings. Mandatory requirement to close any transaction where a existing debt is being left in place must close in a law firm or a title company, or else the transaction is void. Not voidable, void. So we're trying to get the word out to the Texas marketplace here to make sure everybody understands that appropriately. And I'm sure there'll still be some people that filter through and do it the wrong way. So buying a house that way as an investor, I see limited issues. It's just being smart, know the jurisdiction where you are, know your state requirements, find that knowledgeable real estate attorney that understands the business, so at least you can get a good idea of how to manage your business as you move forward. It's the back end, when we sell it to a back end home buyer, as you said, is where all the compliance issues come into play. And really, it's where all the liability comes into play.
So one disposition technique that we see is a lease with an option to purchase. So it's not technically, financing, if you will. It's not a contract for deed. It's, you're entering into a lease, and then you have a separate option for the tenant to purchase the property at some point in time, should they so choose.
Sure.
Is that subject to DoddFrank and the SAFE Act as well?
Technically speaking, I think the answer is no, because when they do that, typically the buyer is going to go out and obtain new financing. And it is not a sale. There's no conveyance of the property to them in some format with a deed or a contract deed. So you're not, as you guys know, a contract deed conveys what's called equitable title, which most people have no idea what that means, versus what a deed does of legal title. So I don't think they're going to be governed by Dodd-Frank. But if I'm the investor selling the property that way, I'd want to have a reasonable expectation that they can acquire the property at some time in the future if that is my goal. Now, a lot of investors who play the lease option game, they're getting a small option fee, might be $2,000 or $3,000, $5,000, versus when we do the creative finance world and we do let's say a wraparound mortgage to a buyer, you might be getting a $20,000, $30,000, $40,000 down payment. So different ways of looking at it. And one of the things that I do, and I make suggestions to investors with, is I get the lease option world. Now, I used to own a mortgage company here in Texas back from about 2000 through 06. I get the mortgage game very well. And one thing I do know is it's easier for a buyer who owns a home, who has created a pay history, to refinance a property than it is to get a purchase money mortgage. And that's pretty much true in any state. So oftentimes, in lieu of a lease option to a buyer, I suggest a wraparound mortgage. Why? Well, you create that pay history, and you can, through various incentives, set it up where the buyer is going to have to refinance or sell that home if your goal is to cash out within a certain period of time. For instance, if you want your buyer to cash out in 3 years, what we do is we do what's called a step-up mortgage in our notes and deeds of trust, where maybe the interest rate is 8% year one, 9% year two, and 10% year three. So that the investor is either going to get so much more money monthly that they're happy, they don't want it to be sold, or the buyer's going to be in a position where they have to refinance or sell or give the house back. Now, you can't do that, of course, because if your investor purchased the home with a lease option. And so we see a lot of that also, where the investors come in and with the seller, they take a lease option. And they do what's called a sandwich lease option, where they then re-option it to a back-end buyer. And so every deal is different. Every seller is different. Every buyer is a little bit different. And it's just learning what your options are to structure a transaction based upon all the various parties who are involved.
Let's talk about the acquisition of real estate using creative financing. So an investor's acquisition of real estate with creative financing. What are the different ways that you've seen that be accomplished? You've already mentioned a lease, option, which, you called it a sandwich lease option. So a lease option, you've mentioned a wrap. But off the top of your head, what are the different ways that a investor can acquire property creatively without having to, obtain hard money or go through and find, a third party to fund the transaction?
So obviously, take the cash mechanisms out of the equation. You've got a few ways. Of course, the first thing is it could be direct seller financing based upon whether or not the seller has existing debt or not, and the seller can be the bank. And what's nice about that is again, limited rules and regulations to do that. There is the subject to techniques where we can agree to make the borrower's payments. And of course, one of the things that we really emphasize here is to always protect the seller using a security instrument, being a deed of trust. And I'm sure you guys have seen this. I had a deal down in Houston where another attorney here in Dallas closed a transaction. There is a deed only from the seller to the investor, no vendor's lien, no deed of trust, but the deed says that they're going to execute a note and deed of trust. And it also says that they're going to assume their underlying debt, which none of that happened. And you read this and you go, guys, what were y'all thinking? So learning how to play the subject to game correctly. Of course, with the sub to game, as we call it, you can add cash to that. You can add a note to it where the seller carries back, let's say, a second lien position. You can add cash and a note to it. Then, of course, the other mechanism is going to be through the wraparound mortgage, which, oftentimes I prefer the wraparound over the subject to, just because it gives the seller the opportunity to maybe structure the deal differently. We can mirror in a wraparound mortgage the underlying terms identically. So it's just like a subject to. But at that time, the seller could create a balloon vehicle if they wish to do so in there, which you cannot do with a subject to transaction. And oftentimes that's a mechanism for the investor to find a way to negotiate the deal a little bit better. From there, if we're buying the property, we can buy with a contract for deed. Even here in Texas, we can do that. And it's really dependent upon who our seller is, what their sophistication is, and what the needs are in the transaction to make it work best for both the seller and the investor.
What are the risks in a subject to transaction, right? Because you're leaving at least one loan in place on the property. So, what are the risks that both the investor and seller have in that type of transaction? So,
of course, the seller has two primary risks, maybe three. One is, of course, the due on sale clause, which, as we describe due on sale, is that it is an option. It is not an obligation for the lender to foreclose. And it's helping them understand what due on sale means. And, I always ask basic questions to every seller. And the first one is what does your lender really want? And of course, the universal answer is their money. Mm-hmm. Do they want to own your property? No. And when you get those out of the way, the little light bulb goes off a little bit and they go, got it. But their credit is at risk. Now, normally, if we're buying that house subject to, they're usually already in financial straits. And what I like to do is emphasize to the seller how, when an investor buys the property, makes payments on behalf of that seller or the mortgage company, we are helping them in the best way possible to increase their credit. Something that they weren't able to do and probably destroyed by not making their payments. They now get to piggyback and their credit gets big bumps because the investor is making those payments in a timely fashion. And of course, one of the big keys is making certain the seller understands how to track those payments, where to look them up, and how to handle things appropriately. And by the way, some sellers do that, a lot don't. So those are the biggest things I think that are out there that sellers need to understand and just walk through it. Sometimes they don't care. They just want out of the deal, and I get it. Other times they do.
One of the things that we're seeing more of here in Arizona, and it's mainly because come January, or as of January 1, there was a major overhaul of our homestead exemptions. And basically it increased the exemption amount, but gave the judgment creditor way more rights. and there's more disclosures and things of that nature that have to happen, upon the sale of a homestead. And then, of course, you have judgments that attach to non-homestead properties. And so I've kind of been mulling over, the idea of, as an investor, you go in and you find a property and you think, oh, this is a great property. And then, of course, you come to find out that, well, yeah, there's tons of judgments out there, and those are all going to have to be, dealt with. One nice thing about judgments, though, they don't require a monthly payment. They exist, they are accruing interest, but they don't require a monthly payment. Have you ever, been involved in or acquired a property subject to judgments? And if so, how did you do it?
Yeah. We've been involved in everything you can possibly imagine. Now, here in Texas, I don't know what Arizona's laws are per se, but in Texas, there's only 3 kind of liens that can legally attach to a homestead, which is your purchase money, mortgage, refinance, etc. A properly executed mechanics lien contract, or it may be a constitutional mechanics lien, which is limited in nature. Or a tax lien. Now, in Texas, title companies got in bed with various other entities, such as the Attorney General's office. And even though a child support lien cannot legally attach to a homestead, title companies will not close a deal unless it's been satisfied and removed. Not a bad way of doing things. I get what they're trying to do out there. And they've also come up with, even though a judgment lien cannot attach to a homestead, they want those removed. And we have a statute here that allows us to remove a judgment lien in 33 days from a homestead. So we can eliminate that in some regard. But have we bought properties subject to judgment liens and tax liens? Yes. Subject to mechanics liens? Yes. Here in Texas, constitutional mechanics liens have 1 and 2 year lives on either homestead or non-homestead properties. Our judgment liens have 10-year lives, and IRS liens have 10-year lives. And so if you're willing to buy that property subject to those liens in some format, I always tell the investors, you can take those over. The question is, are you agreeing to pay those or not? And make sure your contract is written properly so that the seller doesn't think you're buying it and actually paying those off in some format. But we can buy houses subject to the mortgage debt. We can leave these liens on there and navigate it. I love telling a story where we had a property here in the Plano area, which is north part of Dallas. And the property owner had failed to pay a roofer for multiple roofs that were put on some houses. This gentleman wound up owning a homestead that we couldn't do anything with, but he also owned a non-homestead property. And so he doesn't pay, the roofing company files a suit, they get a judgment against him, and the guy files bankruptcy. Well, when you file a bankruptcy, as we know, you have to do your financial disclosures. And the attorney got a hold of those, sent them to me and said, research this, what do you got going on? And we found on this non-homestead property a property tax lien, which is in first lien position. We found an old judgment lien that was 8 or 9 years old. We found a tax lien that was 8 years, or an IRS lien. It was a $105,000 IRS lien that was 8 years old. And of course, here was this judgment lien that was out there. We executed on the judgment lien, bought the judgment lien at the courthouse steps, and bought the property subject to all of those liens. I promptly did a tax lien loan for the then current taxes that were due, which allowed me to pay off the other taxes and incorporate them. So now I protected myself into the transaction with that tax lien loan in first position. And I didn't worry about the judgment lien of the IRS lien. Sure, they could foreclose if they wanted to, but really IRS never does it. And the judgment creditors rarely do it. If they were going to do it, they would have done it a long time ago, but they didn't. They chose not to. We went ahead and moved forward and did a $100,000 remodel of that property. And eventually everything fell off and sold it. So there are always ways of looking at it, and it's understanding how liens work in your state, you know, whether it's Texas or Arizona or anywhere else of that nature, that allows you to learn how to navigate this stuff.
Yeah, we're the same way in Arizona. It's a 10-year period before the judgment expires. However, I don't know if this is the same in Texas. As long as you do it within the 90-day window before expiration of the judgment, you can renew a judgment indefinitely.
Yeah.
But a lot of times, you know, creditors, they overlook that deadline, they miss it. You know, it's been 10 years, they're not even thinking about it. So that's a great concept or strategy and way of looking at it, which is, hey, I can acquire this thing because, you know, it's encumbered every way to Sunday, but yet if I hold it long enough, I may see all of this stuff fall off, and now I'm gonna, you know, be in great financial shape as a result. So,
oh, absolutely. And you know, the key is really helping investors understand this. There is a risk,
right? Oh, yeah.
Navigate the risk appropriately.
Yep.
And that's part of the real estate investment world out there. There are those people who are very risk averse, others not so much. And I think the more you understand judgment liens, IRS liens, tax liens, yada, yada, it does help you to make some decisions and maybe sometimes make better deals on the property.
Scott, wanted to ask about mobile manufactured homes. What kind of creative financing is able to be done, and are you doing in that regard? And can it be done if the mobile home is not affixed to the real estate? Here in Arizona, I'm guessing it might be this way in Texas. It's personal property until such time an affidavit of a fixture is recorded and it becomes the real property. But what kind of creative financing is happening there?
You know, and by the way, I'm glad you brought that up a little bit. And I keep learning more and more about the mobile home industry. I've never been really immersed in it like I have into the real estate. And of course, you know, the first thing I always ask somebody when they bring a deal like this in is it real estate or chattel? Chattel being personal property. Half the time they don't know. So it's like, go find out. Let's either pull a title search, call the state, and there's a way we can check that through the state and determine that. I have seen situations happen. In fact, one here just recently where they bought a property out in East Texas, closed at a title company, and got title insurance on the mobile home and the land. Hadn't been converted to real estate. For the title company, it took them 6 months to hunt people down, finally got it done and got it resolved. But it delayed closing of the back end along the way. So first off, if it's real estate, we get it. That's all easy. It doesn't matter whether it's a manufactured home that's been affixed. If it's deemed to be real estate, it's a real estate transaction. So those are easy. It's when you have the mobile home as personal property. Of course, the question then is are they buying the land through a real estate transaction, and are they buying the mobile home through a non-real estate transaction? Because buying a mobile home is just like buying a car or buying a boat. Oftentimes when we do that here, if it's chattel, we're going to do some type of a installment sales contract on it, as opposed to a full sale. It says, hey man, when you guys make 100 payments of $1,000 a month, we're going to then give you a bill of sale on the property, and we're going to file the transfer of a title document you file here in Texas in order to convey the ownership. From there, though, I think a mobile home, since this is going to be the residence of the buyer, whether they have equitable or legal title, I believe you need to follow DoddFrank, SAFE Act, every rule and regulation, just like you do with real estate along the way. It is so much more wise to CYA. I don't know about you guys, but the first day of law school. So let's go back many years for us, right? I don't know about your law schools, but on every blackboard in our law school, in letters 4 feet tall, was CYA. And it's the same thing with mobile homes, just do it. It's easy. And just stay in line with it. Don't try to circumvent it. Don't try to move too fast. Don't try to be too cute, which is what too many investors do. And then they get in trouble. Whether it applies or not, I don't think I've ever seen that statute per se. I just think that a court, though, would probably rule that if it's going to be their homestead, it's going to apply in some fashion.
Interesting. Well, Scott, we really appreciate you being with. Where can our listeners find you?
Well, here in the Texas marketplace, there's many places they can find us. Of course, as you mentioned, our law firm is Hornet Associates PC, and that I always say it's the French spelling, Horne. That's another conversation for another day. Our website is Hornet Associates. It's hornrealestatelaw.com is our email address on that. In addition, we have what is called the Owner Finance Network. And that is our training website for the creative finance world, where we are vertically integrated, helping the investors provide legal services, title services, what we call the Note Pro, which is loan structuring, whether you're buying or selling. It is where we have our loan processing through OFN loan processing, our loan servicing, because we are also a servicer of owner finance paper throughout the nation, and everything else to do with that. And here in Texas, again, we do one more thing with that. We are a wrap lender now, because now if you do 3 or more transactions in 12 months in Texas, you have to be licensed as an RMLO and your company registered with the state. So they can look us up there. They can call our office at 972-271-1700. And my direct email is scott@hornrealestatelaw.com.
All right. It's been awesome having you. Thanks so much for taking the time. We appreciate it. It's been great information.
No, thank you guys for doing it. I love talking about this. This is what we do. It's close to our heart. We're out in Arizona about 3 or 4 times a year. We'll look forward to dropping by and saying hi when we're there next.
Can't wait to have you. We'll see you next time.
Guys, thank you so much. Great time.
Thank you, Scott.
Bye, y'all.
All right. Scott Horne, first real estate investor and second lawyer. Thanks so much, everybody, for joining us. A quick note for next week's episode. Show Me the Money. Part 2, Are You Raising Private Capital? We're going to have as guest attorneys Paul and Adam Vincent. We'll see you next week.